Hello and welcome to today's episode of IT Galore. I'm your host Kevin Doyle, coming to you from the bucolic banks of River Shannon in Limerick City, Ireland. Today I want to start a discussion on the topic of information technology law. Given that there are different laws in different jurisdictions, I will be focusing on Irish law which that are enforced in the Republic of Ireland. In this episode I will focus on cybercrime, which is illegal activity carried out on the internet. Our discussion will look at a number of Irish legal instruments that are used to make prosecutions. The first instrument is the Criminal Justice Theft and Fraud Offences Act 2001. A clear definition is contextually applicable terms is first defined in sections 2, subsections 1 and 2. Terms such as deception, dishonesty, unlawfully obtained, etc. Section 4, subsections 1, 2 and 6 of the Act go on to define theft of physical property, which could be IT hardware or software encoded on physical media. And Section 9 of the Act deals explicitly with unlawful use of a computer, where a person who dishonestly, whether within or outside the state, operates or causes to be operated a computer within the state with the intention of making a gain for himself or herself or another, or of causing a loss to another, is guilty of an offence. One could see this law applied to remote-controlled computers with compromised security, such as botnets. Section 25 deals with forgery of a false instrument. That could be a document, legal tender, or false credentials. Forensic evidence is often gleaned from computers that can prove that a crime was carried out, and the proving intent in this case is not required. Computer hacking is also illegal in Ireland. Under Section 5.1 of the Criminal Damage Act 1991, where a person who, without lawful excuse, operates a computer, is A, within the state with intent to access any data kept either within or outside the state, or B, outside the state with intent to access any data kept within the state. It is interesting to note that one is guilty of an offence whether or not he accesses the data. As a follow-on to the computer hacking, under Sections 8 of the Offences Against the State Act 1998, it shall be an offence for a person to collect, record or possess information which is of such a nature that it is likely to be useful in the commission by members of an unlawful organisation. Just as importantly, government and public sector data and information is given extra protection under Section 4 of the Official Secrets Act 1963. The state is also protected from an internet-borne terrorist attack, also known as cyber terrorism, under Section 4 of the Criminal Justice Terrorism Offences Act 2005. It defines such an attack as being committed with the intent of seriously intimidating a population, unduly compelling a government or an international organisation to perform or abstain from performing an act, or seriously disabling or destroying the fundamental political, constitutional, economic or social structures of a state or an international organisation. For all of the offences mentioned, penalties include a fine or imprisonment, or both. So that concludes today's episode, where we looked at some of the robust legislation that exists in the Republic of Ireland. Today I covered the Criminal Justice Theft and Fraud Offences Act 2001, the Criminal Damages Act 1991, the Offences Against the State Act 1998, the Official Secrets Act 1963, and finally the Criminal Justice Terrorist Offences Act 2005. So I hope to cover more IT law in the next episode, so come back soon. As I mention in all my videos, if you want to continue to see more of these, please support me by telling your friends about my channel IT Galore on YouTube. Also remember to rate, comment, subscribe, and add me as your friend on YouTube. So I look forward to exchanging ideas with you again, and so until Next time on IT Galore, sláinte and good health.